are used to abnormality in our country, particularly when you have the culture of executive immunity or presidential impunity. We are then tempted to feel that such anomalies are the proper thing. There's no provision of the Nigerian Constitution that allows the president or anybody for that matter to remove an elected official. Between 1979 and now, we have close to 20 cases of our courts which have upheld the right of Nigerian people to be governed properly in accordance with the law. In other words, the law is saying that it is illegal on the part of state governors to remove elected chairmen and councillors and replace them with caretaker committees. Under the Constitution, you can only remove a governor by impeachment, by resignation, or on account of ill health. In the case of a legislator, you can only remove him or her by the process of recall. So there's no provision for, or no law has empowered the president to remove a governor. In other words, you might also say that if the country is fighting a war, say with another country, do you ask the president to be removed by the National Assembly so that a sole administrator is appointed for the prosecution of the war? So it is totally what President Obasanjo did in removing governors cannot be justified under the law. But you know, his regime was characterized by executive lawlessness and impunity.
Hello, everyone. You just heard what Femi Falana said, I think as far back as, is it 2013? I think this should come when that state of emergency was declared in 3 states in the northeast, Borno, was it Jobe? I'm not too sure now, but Borno was one of the states where they declared state of emergency due to the Boko Haram insurgency, terrorism that was going on. And I have just been looking at the Constitution, you understand, trying to see this section 305, procedure of declaration of state of emergency, under which whatever it was, the illegitimate president of Nigeria, the former governor of Lagos State, Bola Ahmed Tinubu, read out in his statement, was based on this particular section that gives a right for that gives a procedure for a state of emergency to be declared. I know I'm not a barrister, but I've been checking and I've read it. I've not seen where it says that you will then suspend the governor. This is someone who was elected, by the people, duly elected. And you can imagine the irony of things as they are right now, where someone who rigged the election is now suspending someone who won an election. Yes, the winning might be flawed. It might be he was brought in by someone, whether induced or whatever, but they voted for him. For me, I always it's not, when it comes to democracy and who gets into office, it's really not about who is it that was voted for, or whether how the person is a simple matter of was the person voted for, was due process followed in terms of that. So you come back to see this, and just looking at this whole thing, let me come back and just take a look at this. So lawyers in the house, do let us know, what does the law give Tinubu the right to suspend anyone? Just like it's also being said that, like, the legislative houses, whether state houses of assembly, the National Assembly, they don't have a right to suspend a duly elected, representative, whether it's at the National Assembly or at the state houses of assembly. We have procedure for declaration of state of emergency, and if you're looking at the Constitution, the 1999 Constitution as amended, 2005. So Section 2005, subsection 1 says, subject to the provisions of this Constitution, the President may, by instrument published in the Official Gazette of the Government of the Federation, issue a proclamation of a state of emergency in the Federation or any part thereof. 2. The President shall immediately after the publications transmit copies of the Official Gazette of the Government of the Federation containing the proclamation, including the details of the emergency, to the President of the Senate and the Speaker of the House of Representatives, each of whom shall forthwith convene or arrange for a meeting of the House of which he is President or Speaker, as the case may be, to consider the situation and decide whether or not to pass a resolution approving a proclamation. For example, here I find this also a bit not too clear, because it's just saying to pass a resolution approving it. So is it the usual yay or nay? In a situation like this, I think it's too serious for it to be left for a usual nay and yay. There should have been that two-third clause, but I'm not seeing any two-third clause. I've tried to look through this. I haven't seen any two-third clause. So first of all, it's for you, he has the capacity, a president has the capacity to declare a state of emergency, which the illegitimate president Tinubu has done with this thing. But it doesn't give him a right to suspend. Neither does it say that you can appoint an administrator. You understand? And if I'm not mistaken, when Jonathan declared state of emergency in those 3 states, these same people were amongst the people who said, no, you can't go and you cannot go and remove the governor. That was why these people were not removed. They were there. As of that time, what's his name now? Shetima and Co were still there as governors while there was still a state of emergency, going on. Subsection 3 says, the president shall have the power to issue a proclamation of state of emergency only when. Subsection 3 talks about the different types at different moments where a state of emergency can be declared. But there's no place where it says a state of emergency can be declared and then you remove the person. So it said, the subsection 3 said the president shall have power to issue a proclamation of a state of emergency only when the federation is at war, the federation is in imminent danger of invasion or involvement in a state of war, there is actual breakdown of public order and public safety in the federation or any part thereof, such extent as to require extraordinary measures to restore peace and security. There is a clear and present danger of an actual breakdown of public order and public safety in the federation or any part thereof requiring extraordinary measures to avert such danger. There is an occurrence or imminent danger or the occurrence of any disaster or natural calamity affecting the community or a section of the community in the federation. F, there is any other public danger which clearly constitutes a threat to the existence of the federation. Or G, the president receives a request to do so in accordance with the provisions of section 4 of this section. And then subsection 4 says, the governor of a state may, with the sanction of a resolution supported by 2/3. Okay, so this is where the issue of 2/3 now comes in. They mention 2/3 here, that the governor of a state, with the sanction of resolution supported by 2/3 majority of the House of Assembly, requests the president to issue a proclamation of a state of emergency in the state where there's existence within the state any of the situations specified in subsection 3C, D, E of this section, as such situation does not extend beyond the boundaries of the state. So like a governor can come out and go and meet the president and say, look, I think I need you to declare a state of emergency in my state when there's like an actual breakdown of public law of order and public safety, then there's clear and present danger of actual breakdown of public order, and then when there's occurrence of imminent danger or the occurrence of any disaster or natural calamity, and even the governor needs 2/3 of the House of Assembly. So far, there is no place where it says you remove and then you remove the person. Declaring a state of emergency, it's not the same thing as performing a coup, because that's what has currently happened now. The president shall not issue a proclamation of a state. So this is subsection 5 now. It says the president shall not issue a proclamation of state of emergency in any case to which the provisions of section 4 of this section apply unless the governor of the state fails within a reasonable time to make request to the president to issue such proclamation. Then 6, a proclamation issued by the president under this section shall cease to have effect A if it is revoked by the president by the instrument published in the official gazette of the government of the federation. So this is where it will cease, it will no longer be in effect. B, if it affects the federation or any part thereof, and within 2 days when the National Assembly is in session, or within 10 days when the National Assembly is not in session, after its publication, there is no resolution supported by 2/3 of members, by 2/3 majority of all members of each house of the National Assembly approving the proclamation. Okay, so in actual fact, I think earlier I was a bit wrong. So this one, it says, in actual fact, for that proclamation to actually go through, they need 2/3 of the National Assembly. And this is in because this makes more sense, because it's not the kind of thing, this is too serious an issue for you to leave it down to the years have it and the nays do not have it. No, it's too serious. So you have subsection 5 of section 305 of the 1999 Constitution as amended. B, is that a B? Yeah, B of it said, if it affects the federation or any part thereof within 2 days when the National Assembly is in session. So this means that when the National Assembly is in session within 2 days, this thing has to be, that's when the state of emergency will know whether it's done or it's not done. Or within 10 days when they are on or not in session, then they need to reconvene, but it has to be done within 10 days. When the National Assembly is not in session after its publication, there is no resolution supported by 2/3 majority of members of each house, not even of one house, of each house of the National Assembly approving the proclamation. So what it means is that members of the National Assembly, 2/3 of both of them, of each of them, must say that they give this thing. And it's not saying they're supportive of each house, not that either house, not 2/3 of either house, 2/3 of each house. Then C, after a period of 6 months has elapsed since it has been enforced. So in paraventure that there is 2/3 has agreed to this, after a period of 6 months has elapsed since it has been enforced, provided that the National Assembly may before the expiration of the period of 6 months aforesaid extend the period of the proclamation of the state of emergency to remain in force from time to time for a further 6 months. So after the first, you can only do first 6 months. After the first 6 months, they will be furthering it, or they will be increasing in it by resolution passed in like manner. D, at any time after the approval referred to in paragraph B or the extension referred to in paragraph C of this subsection, when each of the House of the National Assembly revokes proclamation by simple majority of all members of each house. So if they want to revoke the proclamation, all they need is a simple majority. But if they want to install the proclamation, they need a 2/3 majority. So what the heck is Tinubu think he's doing? What the heck is he doing? You just wake up, declare. You see, this is what happens when you allow illegitimacy to stand. They begin to do a lot of more illegitimate things because they know they can get away with it. You just declare, and then the next thing, you let me calm down.